Friends, today is 116th Friday group meeting. The topic is Section 112 Evidence Act versus DNA test result conclusive presumption against fact. The speaker is our beloved senior advocate, Judge Mr. Sri R.Basant, senior advocate here. Sir, you can initiate your lecture. Before, sir, regular our practice, when the majority of, that, we will have introduction. So that's myself, G.Seshagiri Rao.
Devi Krishna Sarma.
Ajit Kumar. Amit Pratap. Vishal Tiwari.
Yeah. Faraza also.
Oh, yeah.
Sayyid Ahmed.
Akshay.
Anil Kumar.
Sharvanikar.
Please.
JPN Gupta.
I'm Shankar. And me, Basant. Sorry. Now a senior advocate. Formerly a judge of the Kerala High Court. I would like to call myself senior advocate. That's much better to belong to. Having returned to the constituency, I would always like to call myself a senior advocate. The Purva Janma relic I would like to share, and then we one among the lawyers. One more, a little bit of introduction. I started my career as a lawyer at the district level. I had appeared before the first-class magistrate, second-class magistrate. You people may not know a second-class magistrate, and I started my practice in the year 1973. There were second-class magistrates also. Then about 15 years as a trial judge, with a very occasional visits to the High Court. Then another 15 years as a district and session judge. I was called to the bench to the session judge, and then 15 years there. After that, I had 10 years as a judge of the High Court, and then the last 6 years here with you back as a senior counsel. As I always say, I do not propose to give a long lecture or a monologue. Anyone with this amount of experience in life should know something. Should know something where we can share our experiences, and then that's what I try to do. At the outset, I must, as I always do, I never turn down a request from Sheshu, because I love this project so much. When 4 years back, perhaps, when we started this idea, I was greatly impressed by his enthusiasm of getting. When we started that, the idea was so many judgments are being pronounced. We don't discuss judgments. Now, one error that we can fall into is not discussing judgments. If you discuss judgments, judges also come to know that there are discussions, that the judgments are being critically analyzed. I was also a judge. If you don't discuss, if you don't criticize my judgment, I am very happy, because you don't get the feeling that you are under a scanner. To be under a scanner is always good, and therefore if we discuss, not that we are going to tell them, criticize them, but intellectually we can discuss those ideas which it's very good. Therefore, I've always felt that this group like this is very, very useful, because you discuss, so many judgments are being pronounced. And therefore, I'm not saying criticize the judge, but the judgments deserve to be criticized. You need to criticize judgments. Then only the system will improve. As I keep repeating always, there is a chapter in the Constitution. I don't know how many of you are conversant with that. There's a chapter called the Chapter 4A of the Constitution, which deals with fundamental duties. It's perhaps interesting, you will find in 1950, when the Constitution was enacted, we gave unto ourselves this Constitution. This was not there. This chapter was not there. Long later, after 27 years, this chapter came in. This chapter is called the Chapter on Fundamental Rights, Chapter 4A. There's only one article, that is 51A. It has various sub-articles. I'll just like to emphasize one article, because I would like to start with that. See, it says, it shall be the duty of every Indian citizen the word, the section, the article opens, it's not even there, it's fundamental duties. Chapter says chapter on fundamental duties, but it says it shall be the duty of every Indian citizen to do various things. We don't have the time to discuss all that, but one is very important. It says, it shall be the duty of every Indian citizen, 51AJ, when you come to that you will find, to strive for excellence. Well, beautiful. I want every professional to learn that sub-article by heart. It speaks like this. It shall be the duty of every Indian citizen to strive for excellence in all spheres of human activity, individual or collective, so that the nation rises to higher levels of endeavor and achievement. See, there is glory in the endeavor also, not only in the achievement. Please go through the Constitution, read that by heart. Every professional in this country should know that it is duty to strive for excellence, which I find is being performed by him. This group, I find, is really an attempt to discharge the constitutional obligation of an Indian citizen to strive for excellence, and that is the glory of this. And I, no amount of words is enough to congratulate him. The very fact that in a very informal group, what authority does he have to get all of us here? There's nothing. But most of the senior council, when he requests, we don't say no. And the turnout here is also very, very encouraging, because that is what it should be. So with that small introduction, I congratulate each one of you involved in this strive for excellence, and congratulate Sheshu. May this effort continue for long. Every Friday, without break, we are having it. I hope it will continue for all time. He called me on the date of reopening or a day earlier and said, we are starting, we don't want to break it. I want you to come and, do the first lecture. That's what he asked me. Well, then, the first week was always busy. I was on a holiday. I had not looked into anything. So when he said, I was thinking, what shall I speak on? See, I didn't have the time to prepare very much so that I can justify this honor which he has given me to speak to you. But then I thought something which had disturbed me. I think that must be the purpose of a discussion like this. Something that troubles you, something that disturbs you, something where you feel the law is not adequate, something where you feel the judge has not laid down the correct law, something where you think that the strive for excellence, you should have taken a different angle. If you can get at those, that will be the worthwhile discussion that will take place. So I thought something that has disturbed me, something which either as a judge, as a lawyer, or I thought that this should not be the way it is. Then I thought I could perhaps touch on the section 112 or the Evidence Act. I'll take you through that. I know most of you must have, at least for this purpose, I assume that you must have gone through the section 112 of the Evidence Act. It is said, no, I'll tell you. See, section 4 of the Evidence Act, just two sections. I'm not going to take you through the sections in detail. Section 4 of the Evidence Act and section 112 of the Evidence Act may be relevant for what we are now trying to discuss. Section 4 says there are three type of presumptions under law. Presumptions of the may presume variety, presumptions of the shall presume variety, presumptions of the conclusive presumption variety. There are three. Kindly read. I don't want to read to you. I'm not arguing before the court, but read section 4. You will come across these three type of presumptions. I'll read to you only section 4 because that is the most important thing for you. That is a presumption which is conclusive presumption. A conclusive presumption says if you say X fact is proved, then Y fact must be held to be conclusively presumed. It must be conclusively presumed. If A fact is proved, then the other fact is conclusively proved. That is what it says. And then it says, then it shall not be lawful, it shall not be legal to adduce evidence against that conclusive presumption. Let me read to you so that I am not taking you to may presume and the shall presume variety. The conclusive proof variety speaks about this. When one fact is declared by this act to be conclusive proof of another, the court shall, on proof of that one fact or the one fact, regard the other as proved and shall not allow any evidence to be given for the purpose of disproving it. Very, very, very strange. One fact is proved, you presume that the other fact is proved conclusively, and then no amount of evidence will be permitted to offset or to detract from that conclusive presumption. This is the most important thing. The most important thing before I take you to section 112 is, 112 I'll take you is a presumption of this third variety, of a conclusive presumption variety. Now, if that fact is said to be proved, thereafter no amount of evidence can be let in. It may lead to injustice, it may lead to untruth, but this says no amount of evidence can be adduced. Sometimes we call it the tyranny of a presumption. That if truth is otherwise and the law says you have to presume and no amount of evidence shall be permitted to be adduced against that, it can sometimes lead to grave injustice, isn't it? That is why this section in the Evidence Act, section 4, third variety is very, very important before we go to section 112. Now, conclusive presumptions are presumptions against which no amount of evidence will be permitted to be let in. And therefore, those presumptions are slightly tyrannical. We have to go by those presumptions, right? Now we come to 112. Now 112, before I take you, it may not be necessary to read it. 112 is a presumption which adds to, strengthens, fortifies the basic unit of family. Public policy demands that in a society, the family is the fundamental unit of any society. Now this says that if there is valid marriage between the father and the mother, and during the currency of the marriage, a child is born, or within 280 days thereafter, the child shall be presumed to be the legitimate child of the father. Right? This is very important. I'll take you through 112 because that again is a presumption of a very, very, shall I say, very. It can create a lot of confusion, as I will tell you now. This presumption says, if the father and the mother remain in matrimony, valid marriage, and a child is born during the kavarcha, during the period of marriage, and 280 thereafter, the wife remaining unmarried, then the law says that the legitimacy shall be presumed. Now, I'm taking you through some interesting discussions on that as to what this presumption is, to what extent it can go, because all of us generally say 112, okay, presumption of paternity, right? Everyone seems to feel that 112 is a presumption of paternity. Now, I'll take you through 112 and some discussions on that to show that is it really a presumption of paternity or is it only a presumption of legitimacy? Indian law has not advanced much on that, but it's a good thought for you, and therefore I thought we must highlight that. Now, I'll take you through 112 presumption. 112 of the Evidence Act, this is what I've already told you, but in the context I wanted to specifically, birth during marriage, conclusive proof of legitimacy. Birth during marriage, conclusive proof of legitimacy. To understand this section, you must also know what conclusive proof under section 4 is. Maybe one more expression as to what legitimacy is. Is it paternity? Is it just a synonym for the word paternity, or is it something more or less than paternity? We'll have to discuss. But what it says is this: the fact that any person was born during the continuance of a valid marriage between his mother and any man, or within 280 days after its dissolution, the mother remaining unmarried, shall be conclusive proof that he is the legitimate son of that man, unless it can be shown by the parties to the marriage, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been conceived, when he could have been begotten. So look at this presumption. The presumption is a presumption of the conclusive variety, but 4 says that no evidence can be let in at all if there is a conclusive presumption drawn. But here it says small window is kept open, a very small window is kept open, which says there is only one manner in which you can rebut this conclusive presumption. So it's not a normal conclusive presumption as stated in section 4. 112 says it shall be conclusively presumed, but there is a small window. That window is, if you can show that there was no possibility of access between the husband and the wife at a time when the conception could have taken place, you can prove that and the presumption will vanish. Right? Right? It's a different type of a conclusive presumption. I read to you section 4 to say that no evidence will be let in at all. But 112 makes a deviation from that rigor of that conclusive presumption to section 4 and says, yes, it is a conclusive presumption, but there is a small window left but through which you can get out if you want. And that is the proof of non-access. As I read to you, unless it can be shown that the parties to the marriage had no access to each other at any time when you could have been begotten. Now I take you to the purpose of this presumption. As I told you, family is the fundamental unit of society. The faith in the family, the order in the family, and consequently the state all demands that there should be no unnecessary disputes regarding paternity. The door should not be open for either the man or the woman to say, yes, we were in marriage, but this is not the son of you. That should not be there. Either the mother or the father should not be left with the option to say that somebody is born during marriage, that person is not the son, unless you prove that there was non-access at a time when they could have conceived, when the child could have been begotten. This in turn leads to many other questions. I am not going to take you through that. Now one of them is, when the child could have been begotten, right? That's a very important thing. Non-access, when you try to prove, it must relate to the time when the child could have been begotten, could have been conceived, or in other sense, when the man and the woman could have had sexual intercourse. That is the starting point of life, and where they could have. So that the presumption for read with 112 also demands that there must be some material about that time when the child could have been begotten. Right? When the sexual intercourse could have taken place. Now, it makes interesting reading if you read that, when James Stephen, this is in 1872, this presumption of legitimacy came in 1872 when the Evidence Act was enacted. So far as India is concerned, similar presumptions are there. Now, in one of the commentaries you will find, why was this presumption of non-access permitted? The British soldier comes to the Indian soil, and then his wife begets a child there, he could not be burdened. Right? And that is why in all the places you will find the worry of the law at that point of time, it is a commentator's view. One of the worries was that such injustices should not take place. That is why a small door, small windows left open. That at the time when the child could have been begotten, we may have to calculate, isn't it? When a child is born today, when could he have been begotten? It means you have to go back in time, and that is why this 280 days becomes important. Normal period of gestation is assumed to be 280 days, so the conceivement of the child could be sometime before, within 280 days, backwards of the date of birth of the child. This is important. So all these concepts are important. I am not going to take you through all that. And when situations come, I am sure you will study them for your purpose. My point is only that one or two things. That is, what is the presumption? Is the presumption of paternity or legitimacy? Is there a distinction between paternity and legitimacy? The law very carefully says the child shall be assumed to be legitimate. Now, Indian law has not advanced much on this concept of a distinction between the paternity and legitimacy. I'll just give you one suggestion. You go through that, because I may not have time. Justice Ravindra Bhatt, in a decision rendered when he was here, as early as on 23/12/2010, deals with this possible distinction between legitimacy and paternity. Now, why that again is important? Because the child must be held to be legitimate. The law frowns against bastardizing a child. because the child's interests are protected. And legitimacy would give him certain rights. Paternity would hurt the father if he is not the real father. So there is a discussion going on internationally now whether you can make a distinction between paternity and legitimacy. See, for example, adoptive father will also be liable to the child as if it is legitimate. Right? You understood that. See, all the incidents of responsibility would be there for the adoptive father also if the child is adopted by him, because that is a legitimate relationship. So there is a discussion going on, a thought going on as to whether you can really make a distinction between legitimacy and paternity and say that this only presumes legitimacy and not paternity. If that happens, it's going to be, what remains in legitimacy if you take away paternity? Supposing you say a child is legitimate, but I'm not the father. This child is the legitimate child of mine, but I'm not the father of the child. Such a distinction appears to be possible. Read that decision by Justice Bhatt. I'm not going to take you through that in detail. You get it in, give me the citation, Manupatra, Delhi 3701 of 2010. But kindly make a note, because I may not have time to take you through all that. That's a thought going on, borrowing from international development of jurisprudence elsewhere.
What is the case title?
Case Rohit Shekhar. You must all have heard of this. This is the Narendra Tiwari case.
Okay.
You know, Rohit Shekhar versus N.D. Tiwari and others. I'll repeat, Manupatra, Delhi 3701 of 2010. Read that, because you will be taken to higher levels of discussion in that, because the time at my disposal is short. I don't have one day I should be devoted to that if we have to discuss that in detail, but let's leave it at that. You read it, it's interesting reading. Only those who are particularly interested in the development of law on this aspect will find time to read, will be interested in reading, because I'm not going to take you through all that. But it's very interesting. Very interesting. His Lordship tries to look at international development of international jurisprudence, this concept in international jurisprudence, and tries to find out whether a distinction could be made. Right now, let us be very clear, in the Indian law, that distinction is not highlighted. Now, so legitimacy has always been understood to be a synonym for paternity also, so far as the Indian law is concerned. But an area of development is left open. It is possible that we may on a later date make out the distinction between legitimacy and paternity, though I am at a loss to find out what would remain of legitimacy if paternity is taken away. Be that as it may. In my thought, I thought this adoptive father is one instance, where you are not the father of the child, biological father of the child, but the child can still be legitimate, because of the process of adoption, which recognizes that all incidents of biological parenthood also fall on you, but except the real paternity. That is of course not there. Okay? Read that, try to understand that. Now, what I am really concerned with, what I thought I'll discuss with you today, is the presumption and the fact. This is a presumption. Conclusive presumption, you can't change it, but the fact could be different, right? Given the moral degradation that takes place, the societal attitudes, you always have got to remember, this was enacted at a time when even contraceptives were not there, right? This presumption was enacted at a time when even contraceptives were not there. See, so many things which we today are aware of to prevent pregnancy were not there at that time. So that it's very important to understand, in order to understand the section, you may have to travel back in your mind to the can I call it the dark ages, where the scientific and technological developments were virtually zero on this aspect. You couldn't even prevent a pregnancy. That was the type of the times that were there when this was enacted. Of course, in a 1951 Canada decision, which my junior Akshay traced for me, I found that this is also discussed. If you're interested, go through that also. Give that citation also. It is 1952, 1 Canada SCR, They don't call it Canada SCR, like our SCR doesn't call it Indian SCR, they call it 1952 1 SCR 3 Canada. There even this question is referred to. It's interesting. Interesting, if any one of you is interested in reading further into that, please go through that. It deals with this question of, there was a case where the husband and the wife said, we were using contraceptives and therefore there was no chance of access, but the child was born. And if the child is born, the presumption comes, unless you prove non-access. Now, if you are together in a bedroom and if you perform the sexual act also, non-access will not be available at all. I am talking about the law as we have understood so far. See, because the question came as to what is non-access. It's very difficult to prove what happens inside a bedroom. And therefore, the law developed in such a direction, and it said, opportunity for sexual intercourse is access. If there is physical proximity and an opportunity for sexual intercourse between spouses, you cannot establish non-access at all. Right? Very, very, very reasonable at a certain point of time in the development of scientific knowledge. See, because otherwise you can't get into the bedroom and see what they are doing. What you can do is only, the access was interpreted to mean physical proximity and the opportunity to have sexual intercourse. That is all that was there. So, if the husband and wife were living under the same roof, or even on occasion when they could have interacted with each other, you cannot say, no, I had nothing to do with this woman, I did not procreate. I am not responsible for the fetus, I am the child, because you know that for certain, you know that it's a fact, the lady may also know it's a fact, but the presumption would be loaded against you, and you will be imposed, or the burden of being a legitimate father will be there. So the question arose. The many cases you will find, I'll give you at the end of discussion, whoever is interested, take that list of citations from him. He will tell you, the court had a big problem trying to interpret what is access and what is the burden of proof on a person proving non-access. So that is why it was held at a certain point of time, access means opportunity for physical contact. Opportunity to have sexual intercourse. That was enough. Whether you actually had or not was no defense at all. So that you could not say, yes, we stayed under the same roof, but we had no intercourse at all. That is not non-access. Non-access is absence of physical proximity and absence of opportunity for sexual intercourse. That is how a line of decisions of the Privy Council and the Indian Supreme Court said, you can't go farther than that. As soon as it is shown that he had no access, in the sense there was no physical proximity and no opportunity for sexual intercourse, the presumption cannot be rebutted. So look at the plight of a poor man who is convinced that he is not the father. Right? See, everyone does not go to India as a soldier. But he may be in his heart of hearts convinced that I have not had anything with her. I was quarreling with her all the time. I never slept with her at all. But the presumption would operate forcefully and say that you are the father of the child. Well, how can this be dislodged? Is there a way out from this? It's one thing to say the societal interests want the presumption to be there. It is one thing to say that the child cannot be bastardized, the child's interest must be there. But what about the trauma of a man who is convinced that he is not the father, but the presumption is there against him? That is what it's interesting. An English court in an All England reporter, I'll give you a citation, thought of this and said, the injustice of presumption versus the justice of fact. Right? If the presumption cannot be dislodged. So they said, the great trauma would arise, all laws are geared up to maintain harmony in society. If a person lives with a seething discontent that the law makes me the father of a child, which I am not, that is not conducive to harmony. See, justice is doing justice even to him. And therefore, there was a line of thought saying that how non-access is to be understood. See, and the Supreme Court clearly held what is the burden of proof to prove non-access. To to dislodge this presumption, what should be the nature of the burden on a person trying to discharge the burden? Some people said, no, it must be proved beyond reasonable doubt as in a criminal case. Some people said, no, it is enough if the balance of probabilities is satisfied. Now, courts have held that it is neither that nor this. It is not the extreme burden of proof beyond reasonable doubt as is applicable in a criminal case, nor is it a mere preponderance of possibility. It must be something more. It must be something more. Which means people have to adduce evidence in order to get out of the rigor or the presumption that there was non-access. And how is non-access proved? If you were both sharing the same roof, no non-access at all. As I told you, physical proximity is sufficient. Actual sexual intercourse, you don't admit evidence on that. Non-access alone is the evidence permitted. And therefore that is also not possible. So that you will find a long time this started and you were a victim. Two interesting things that I have read about Singapore's illiterate citizen who said he had a neighbor, a Chinese neighbor. When the child came out, it had all the features of a Chinese person. So this man was morally convinced or reasonably convinced that it was not his child and the neighbor was responsible for it. There was some quarrel, murder, etc. Leave alone that. And he told the court, when the court argued, he said, forget about all your presumption. When potato is planted, potato has to come out. When potato is planted, how can onion come out? See, this was his argument. Very good argument and a very commonsensical argument. He said, forget about all your presumptions. But how does this happen? So it revolts against my sense of common sense, my sense of knowledge, my sense of justice. It revolts. So he said, how does this happen? Now, it's an interesting story which I read. This man, he does not have a lawyer, he did not have a counsel, but in his own very, very, very mundane way, he argues before a court. Potato planted, potato must come out. How is potato planted, onion coming out? See, this is the dilemma. This is the dilemma of law. If you have such a presumption, how will you get out of this? Now, there is also one reported, in this decision, if you read, it refers to another case where both parents were English. For generations, genealogically, they were English people. But when the child was born, it was a black. Right? And so, the presumption would operate. You may be morally convinced, you may be 100% convinced it's not your child, but the presumption would operate. And so, these are some of the instances where the injustice of the presumption prevailed over the justice of the fact. That is why we start thinking how you can get out of that. Because the only evidence possible is non-access. And if you understand the expression non-access as appearing here, no access, and as interpreted by the various courts in various jurisprudence also, it is only physical proximity. There should not be physical proximity. I and my wife, if we are seen together sitting here, we may not have shared a bedroom at all. If you do that, the physical proximity cannot be disputed. Now, several cases, as in one case that I referred to, they say, we had always used a condom. There is no possibility. All this evidence is impossible. If there is opportunity for physical intercourse, then all this evidence will not be let in. That is what Section 4 says, that is what Section 112 follows it up. And therefore, that is the dilemma of law. But remember, this was at a time when the paternity could not be ascertained scientifically. Right? Today you have traveled a lot of distance in science and technology that you can, with 99.999% accuracy, that's what an Australian court said. The Indian courts have also repeated many times that a properly conducted DNA test is 99.999% conclusive about the paternity. It is 1% is about a mistake that could do it. Or because no one ever confirms. No, because the principle is something like this. You must have read about the DNA test. It is about the analysis of your cell structure, and then if the DNA, RNA and the DNA structures match, you can assume, because a child, looking at the chromosomes of the child, you can say from which possible father and mother it could have come. It may not be possible to authentically state that at a certain point, but you can exclude. The science developed that way. Earlier, it said you can examine blood samples and then say, you cannot say he is the father of the child, but you can say he is not the father of the child. Right? You can say he is not the father of the child. Even this decision deals with that, as to what it is, how the tests are conducted. So that the revolutionary changes in science and technology started shaking the foundations of the 112 presumption. Today I would say, as I said in one of my judgments in the Kerala High Court, the 112 presumption is today shivering in its shoes, because the presumption may not live longer. Science and technology have taken us to such an extent now that this presumption may not at least be conclusive. I can say you may presume, you shall presume, but the opportunity to rebut that must be there. On all evidence that is possible. A DNA test result must be produced to show that I am not the father of this child. Then you can't say, because of your 112, I'll throw your DNA test out. Because it is not evidence of non-access. You can prove only non-access, and when you come with a DNA test certificate, the court can legitimately say that no, I'll not look into it. Don't get the DNA test result here at all, because you are bound by the 112 presumption. And therefore you have no evidence of non-access. Now, in fact, it is interesting, in a decision in Kamti Devi, I'll read that paragraph to you. Kamti Devi, this Supreme Court said that no, DNA test cannot be touched. DNA test cannot be introduced. Get me that? It cannot be. I'll just read paragraph 10. You read that decision. I'll give you the citation. This also you must read. If you're interested in the subject, you must read 2001 5 SCC 311. Kamti Devi versus Poshi Ram. You can get the citation when the list that he has. I've asked him to keep it typed so that any one of you want. Now, that case, there was no DNA test as such conducted in that case. But Justice Thomas, as he is, looked at the larger context of law and then said, even though there is no DNA test, 112 presumption is so strong and it is virtually irrebuttable except by evidence of non-access, that even a DNA test result, if you produce, the presumption would remain irrebuttable. I'll just take you through that passage. Now, it was a little shocking for me because, as I told you, the potato, onion cannot come out. Black parents, lineage complete, the white parents, black cannot come out. So the presumption cannot be held to be the be-all and end-all in the search for justice. I had a case like that. That is where I had occasion to consider this aspect. A case when I was a judge. A case like that. That is where this question was thrown up, and I had to consider it. Disturbed me. All good things come out of disturbance. You must be disturbed. You must be disturbed. When a court here passes an improper order, you must be disturbed. When a court passes an order which you think is not just, you must be disturbed. You must think of how to get over that. It must disturb you. Now, if you accept everything, in the hierarchy, the highest Supreme Court judge just said it, oh, I'm very happy. You are not contributing to the development of the law. You are not contributing to justice in its fineness. And that is where it must disturb you. The man who said potato planted, how onion is coming, speaks of an agony within. That agony must disturb you. As law persons, it must disturb the lawyer and the judge, and we must be prompted to think aloud as to how we can avoid this if possible. Of course, at a certain point in time, it was impossible to avoid that. Now, Justice Thomas in the decision, I'll just read to you this. We may remember, this is paragraph 10 of that decision, we may remember that Section 112 of the Evidence Act was enacted at a time when the modern scientific advancements and the RNA, DNA tests were not even in the contemplation of the legislature. The result of a genuine DNA test is said to be scientifically accurate. But, this is the crucial line, this is the most, according to me, the unkindest cut of all. But, even that is not enough to escape from the conclusiveness of the 112 presumption under the Act. For example, if a husband and wife were living together during the time of conception, but the DNA test revealed that the child was not born to the husband, the conclusiveness in law would remain irrebuttable. This is what the Indian Supreme Court held in 2001 5 SCC. So that even if the court also says the DNA test is said to be accurate, and there are n number of decisions for that internationally also recognize the DNA test as correct. But in spite of the DNA test, it says it will be irrebuttable because DNA test was held to be not proof of non-access. And therefore it was said that you cannot rely on that. This will not be possible. When I dealt with a case, as I said, in a Roslin versus, what is that decision? Rajesh versus Roslin in the Kerala High Court, this was the law. And said you cannot look into it. So then this cannot be the law according to me because it works out injustice. I know as a matter of fact from scientific evidence before me that this is not the father of the child. Then can I turn around and say, no, you are the father of the child because 112 says so. This disturbs you. And that is why we had to do some research. The council did not argue. We appointed a amicus and wanted the amicus to look up. I'll give you the citation. Please read that also if you want. And then the question was, can a DNA test result be introduced in evidence to rebut the presumption under 112? That was the question that was raised. This said it is not possible. This said it would remain irrebuttable even if you have a DNA test result which is scientifically said to be accurate. So that is where the thinking comes in, the problem comes in. Now then, what are the ways of getting out of this? This presumption is there. See, you have got to, as a judge or as a law person, committed to your law. Rule of law is your commitment to law. You cannot simply say it will be admissible. You must reason out and say it will be admissible, it would come within the parameters of 112 and section 4. Now of course, Supreme Court under 142 is there, they can always say it is so. But then when you sit in the High Court or when you argue a case, you will certainly have to build up under the existing law, I must be able to introduce the DNA test result. How does that happen? That is the question. That is the question then. Now, there have been two later decisions of the Supreme Court on that, 2004. No, I did not tell you. No? Did I give you this citation now? Now, Rajesh versus Roslin. Preeti Roslin, you will get in 2012 SCC online Kerala 5356. You will get to give you that decision if you want. 2012 SCC online Kerala 5356. It's also reported in many other judgment journals where you may have this. You don't have the head notes. But some of the other you will get the head notes. If you think you're interested, you can do that. Find out that. Now that is it is while discussing that we came across that presumption. Where is that? The English decision, All England report decision, which said an All England report decision which spoke of the tyranny of a presumption as against the justice in facts. How can you do that? No, the very, very interesting. I'll just read one line that comes in 1966, one All England Reporter, Law Reporter 356. It says, when the Lord Justice Ormerod in 1960, when as I think in these days, it is possible to enable the courts to do justice on a footing of fact and not to do injustice on the basis of a presumption. I should myself greatly hope that no difficulties will ever be put in the way of a child's blood being supplied for blood grouping. I know that it is a sad thing to bastardize a child, but there are graver wrongs. And this is a matter which I am sure all those concerned will approach with great caution, because there is nothing more shocking than that injustice should be done on the basis of a legal presumption when justice can be done based on a fact, on the basis of fact. The learned English judge was not considering DNA, he was considering the blood test. I told you, under the blood test it was possible to exclude, though it was not possible to include under the blood test. DNA test you can now include also. Right. And that decision, the question came, how we can introduce a safe, scientifically accurate DNA test result into evidence as permitted under section 112 and section 4. Section 4 read with 112, non-access is the only manner in which you can. So we started thinking, see, what is access and what is non-access? In the age of ignorance, access was physical proximity. It could be opportunity to have sexual intercourse. But when science and technology develops, when you can say for certain whether this is the child is born out of the fruition of the ovum and the sperm of this lady and this man, how can you understand the expression access? See, we took the view in that case that access in the modern context, when you have the advantage of science and technology in the form of a DNA test result, must be interpreted as access of the sperm to the ovum and not the access of the man's hand to the wife's hand. Well, within the law itself, if you would explain, understand access consistent with modern times, consistent with modern science and technology, then you have got to understand this is access spoken to is not the physical access or the physical proximity. You can give a more dynamic interpretation to the expression access and say access for the purpose of paternity, for the purpose of legitimacy, it is the access of the sperm to the ovum and not any other. So it was suggested that we can now take a different view and understand the expression access different from how we have understood all along in the age of scientific and technological darkness. And now that since we have these tools, we can't squander these tools and say, I am a prisoner of the presumption under section 112. Within 112 itself, you have sufficient leeway today to interpret the expression access to include, to mean access of the sperm to the ovum and the fertilization and the birth of the child. So it was felt in that decision, this is a division bench, I was sitting along with a brother of mine, we took the view that the access in section 112 must be given a different, wider, more dynamic meaning today because we are trying to understand an 1872 provision in 2012. When we do that, we cannot squander away all our common sense and say that I am a prisoner of section 112. So we said, look at law conditioned by the circumstances you have today. Today you have to interpret a statutory provision. We are not a prisoner of the interpretation even in Kanti in 2010. We were doing it in 2012. We said Supreme Court had not considered this aspect, so we don't think we are the Supreme Court decision rules out that possibility. Maybe the Supreme Court did not consider that, and what is not considered, we have the option to reconsider. And therefore we said we can consider that. And so in this decision we held that access in the modern context, in the light of the purpose of which the presumption is made, you have got to understand it as the access of the sperm to the ovum, sperm of this man to the ovum of this woman. And in the DNA test, what do you get? The result is that this sperm did not access this ovum. And therefore, it is perfectly within 112 to take a view that the access spoken to there in the modern context must be understood as access of the sperm to the ovum and not physical and not mere physical proximity or even the opportunity for sexual intercourse. Well, that is why I said section 112 presumption, we have said in the judgment, must be shivering in its shoes now. Today, it is for the legislature to decide whether the conclusive proof which section 112 says it is today can be watered down to a presumption of the may presume or the shall presume variety. But it cannot continue one day longer as a conclusive presumption. We said in the decision, Maneka Gandhi decision interpretation says, a law has to, in order to pass the test of reasonableness, must be fair, just and reasonable. Article 14. If you interpret section 112 to mean this scientific test has to be squandered and you cannot look into it, you are making law unreasonable, offending the Maneka Gandhi dictum. In order to attract, in order to be within the Maneka Gandhi dictum, you have got to understand 112 in such a way that access can only mean access of the sperm to the ovum. We said, we hoped that the legislature, because it depends on so many things. Today, as you know, the opportunity for testing DNA is not available all over the country. You have to send them to the Hyderabad lab or some very specialized. Maybe until that test becomes available for ordinary people, the presumption may for some more time continue in the conclusive presumption variety, but I am sure the journey is going to end. This journey will not go on forever. As soon as we have the opportunity to adduce scientific evidence, we will definitely come to a conclusion. The law will take a view that the evidence of non-access in the form of DNA report can be accepted, and that is evidence of non-access. Right? This is what has been held in Preeti versus what is that? Rajesh versus Preeti, because it laid down something different from how we understood the law. Kamti also, because you know it was a little risky to do that. As you understand, the Supreme Court had very clearly held that the presumption would remain irrefutable even if a DNA test result is produced. So we had to wriggle out of that. So we said yes, the Supreme Court had not considered this aspect, but in the modern context, we have to give an interpretation which would make the provision constitutional under Maneka Gandhi, so unreasonableness cannot remain, and therefore this is a better way of interpreting. Now this is what the law in Kerala today is. Now I'll tell you thereafter, this came in 2012. This decision came. Thereafter in 2014 and 15, there have been two decisions of the Supreme Court. It's interesting. Now I have my disagreement with the Supreme Court decision, even though they say that the DNA test result can be accepted, because they did not interpret access. They only said, I'll take you through the relevant passages. You know, we are only discussing generally, we are not criticizing the judgment as it is, but they said this is a scientific test, that is the presumption, and therefore it can be. They did not explain how you can bring it within 112. See, 142 is there for the Supreme Court. They can say anything that they provided they think it's reasonable. The conclusion appears to be reasonable, but the reasoning that non-access, the DNA test result is also evidence of non-access, is not stated in either of those decisions. Though they say the DNA test can be conducted and can be looked into in questions regarding paternity. There are some distinctions. You can always distinguish those decisions, because in one, parties agreed and conducted a DNA test, and the question was only whether that could be adopted in evidence or not. In the other, the paternity was not the question. The real question there was, husband said, you are adulterous. And to prove that adultery, he said, you have conceived by another. And adultery, as you know, if the man or the woman has one instance of sexual intercourse with another outside marriage, it is adultery. So if you have conceived a child other than through the husband, it amounts to adultery. So he tried to establish, not to dislodge the presumption under 112, he tried to establish it by saying that you are adulterous because you conceived a person other than my child. You have conceived from some other person, and therefore you are adulterous. Both those are not directly on the question, and this question did not really arise. But what is stated in the earlier decision, what is the name of those two decisions? Give me. 2014 is the decision Nandalal versus Lata. Go through those decisions. It is, they have, where do you have the page numbers? The relevant paragraph 16 to 19. Please go through them. And the other decision, the earlier decision is Dipanvita Roy. Dipanvita Roy versus Rono Roy, and there you get the relevant discussion at paragraphs. Tell me, paragraphs 13, 17, and 18, right?
Yes.
13, 17, and 18 you get.
What is the citation?
It is, I did not say, 2014 is Nandalal versus Lata, I told you. The 2015 is Dipanvita Roy versus Rono B. Roy. They do not really consider this aspect. There is no reference to the Kerala High Court decision on that. as to whether within 112 you can say that it is perfectly legal to adduce that evidence. They only said presumption, the scientific evidence is more important than the presumption, but that will be not addressing the question of 112. That does not explain the language of 112. You have to be bound by the law, and if that you are bound by the law, you have to say how the presumption can be got over. And the presumption in the light of 112 can be got over only by evidence of non-access. Whatever evidence you adduce, you have to show that it is non-access. It is. In this context, you find this, I think we've tried to do justice, the tyranny and the injustice of presumption. We try to look into it and say, within the law itself, under the scientific development, ignore earlier, outdated, you must have seen many decisions. Constitutionality today may not be constitutionality tomorrow, because circumstances may change and it can be. A number of decisions saying that every statute is to be interpreted at a given time in the context in which you are applying it. And therefore what was constitutional yesterday may today become unconstitutional also. In that view of the matter, I feel 112 must be held to be unconstitutional if you read and understand it that the DNA test result cannot be admitted at all. This is the point that I thought we'll discuss. If I have provoked your thoughts, good. I will be very happy if we have provoked thoughts to find out how justice can be done. See, ultimately, why are you a lawyer? Why is somebody else a judge? The basic purpose of the system is not to make money, but to do justice. In the process, you get money. In the process, you get name, all that. But then, if you lose your commitment to justice and truth, we are just mercenaries. We are not good lawyers and judges. That is the most important thing. And that is why discussions like this may be of help to you. Thank you very much for the patient discussion. Yeah. Any questions? If I can answer.
One second. Thank you very much, sir. Really, after reopening, you ignited the Friday group. Excellent thought, and it's a rare. First time we discussed this subject, last when the 116 topics we discussed. Really, it's even villages also this is a regular problem. What I noticed. I mean, thank you very much, sir. Now question answer.
One question. A husband and B wife, they can't birth any child by medical. Then they will decide for stem cell. One child can be stem cell. And A wife and B husband stem cell or in another woman C womb. And birth is C, wife is C and born a child. So what is the paternity and maternity? He is on the womb of C. Can it be changed to A, B, son or daughter?
You are taking me to the larger questions of surrogacy.
Yes, surrogacy.
Surrogacy. You're taking me to the larger questions.
Yes.
See, a person can donate not the stem cells, sperm cells to the bank. You find so many sperm banks coming in. What do you call it?
There is sperm and because it's a medical.
Yeah. No, whatever explained. In fact, what is being contributed is not the stem cell, but the sperm. You have a sperm bank, and you have the ovum bank. Now, ovum from a woman can be taken and planted in somebody else's cell. And then the question comes: who would be the legitimate father, mother? Earlier, there could be no dispute about legitimacy of the mother. Mother was always a fact, and the paternity was an opinion, as it has been in lighter vein said. Paternity is only an opinion, whereas motherhood is a fact. Now, if you have mother's ovum being taken out and planted in somebody else's womb, and it developed there, even maternity may be a disputed question. Now, I am not at the moment competent to answer this question, but these questions are being dealt with by the law. But see, a stem cell person, a person who has contributed his sperm to the sperm bank should not be fastened with the liability of a natural father, biological father. The thinking on these lines are going on. May not be able to give you exactly what it is. Merely because the sperm is yours, somebody else cannot years later say, I got a sperm from there and the DNA test it is you and therefore you are the father of my child. No, maybe. Law has to provide for against such contingencies.
Here the case is not sperm or ovum, it's only stem cell. Stem cell is another means of the production.
Sir,
If
obviously.
I don't know. I am not competent to give you a more authentic opinion. Right, I see your point. What is stem cells? Stem cells are different from sperms in the what do you call it? IVT, no? What do you call it? IVF, right? Yeah. IVF process is entirely different. There's no need of a stem cell there. What is happening today in the modern science and technology? What happens is a person is requested to contribute sperms, and they are preserved. And you have heard that. We ought to have preserved sperms of Einstein and then others, and then so that more scientific community would have come in. Thoughts like that are going on. But what is happening today, you take sperms either from the natural father because the mother is not able to conceive, and then you fertilize it outside and plant the fertilized egg into a mother's womb or a surrogate's womb. And then all these questions about who would be the father, etc. Surrogacy, if I remember right, twice the bill has been introduced. It has not been finally passed, is my impression. I am not able to give you a competent opinion. My general reading tells me that Indian law has not come with specific provisions, and that is what I feel. I'm not too sure. I have not had occasion to study that in detail.
I had one more example, as you have said, that a great anguish. There is the presumption and the fact.
Yeah.
Suppose an important husband marries with a lady, and during the subsistence of the marriage, child born, and admittedly he is important, there is an excess, they are living together. 112 will raise the presumption that you are a father, but biologically he can't be the father. So therefore, how this will be proved unless until you rightly say.
More appropriate would be a sterile husband. The potency may not be correct. Okay, right.
So therefore, it requires an interpretation in a way that you should be given an opportunity. Otherwise, 112 shut the door.
Yeah. Oh, that's a problem. Actually, that's a problem.
Therefore, I am only giving the example of your
That is why I called it the tyranny of the presumption.
Yes.
It's a tyranny of the presumption. When you say no better evidence, and the court itself says it's accurate. If it is accurate, to say that you will not look into that evidence is unjust according to me.
So on this topic, sir, I was reading when I came to know on WhatsApp.
I'll come after this.
Through reading, I came to know that our law commission, it has given its report on this, section 112 amendments, and it has recommended 3 amendments, that medical test for impotency, blood test and DNA test, and 185th report is that.
Right, it does not come into law yet. I saw that, with my juniors placed before me that, which is that, 185th report of the law commission, we saw that, but since it did not become law, I did not want to touch on that.
So it means we agree upon these. So in this circumstances or present scenario, we can also make some changes. We can also request to the court to make some changes on the basis of this report.
According to me now, you don't have to change the law. As I look at it, the law offers sufficient elbow room for an innovative lawyer and a judge to get out of it. Right? See, the law has it. The law already has it. Of course, it is true that because, there are more hurdles that you have to cross. Because they say you cannot simply ask for a DNA test. You have to lay foundational facts in order to request the court to get a DNA test conducted. If the law is amended and then wherever there is doubt, they can resort to that. Now, I did not take you through that. Gautam Kundu and many other decisions, they said, you cannot ask for a DNA test straight away. The husband may, in his mind, have a very honest doubt. This case which I dealt with, how it had happened is, the child was born. There was no distrust between the husband and the wife. But somewhere down the line, the man started entertaining a doubt. So he took the child out for something and then took it to the laboratory, got its blood tested with his own blood to get the DNA test conducted. Without the wife's knowledge, actually. That's how it happened in that particular case. In the case, that is Preeti versus Roslin, what is that? That case, Rajesh versus Roslin, that was it. He had that. Then he wanted his wife to do that. No, she did not know the intricacies of science and technology. She also agreed. And they went to court, the court agreed. When the negative result came, she said, I wanted once more test to be conducted. And that test was also conducted, the place where she wanted it to be done. It is after that that the question came up. Because today, most people are unaware that this closely guarded secret will come to light. So they may not know, they may agree for a test, and it's only after the result comes they would come to know of this scientific and technological development. Earlier, groomed in the tradition that you are, one could never find out unless the potato onion comes or English parents get a black child. Otherwise they will never know. You might assume that everything is fair, no problem. No, that is where we are today dealing with a knowledge society. Gone are the days that people are ignorant. No, before a person comes to you for discussion today, you lawyers will find that he has already read the law. He already knows which decision is in his favor, which decision is against us. He goes and consults at least 3 lawyers before coming to a senior counsel like me. So I ought to know the law. If I do not know the law, he is going to ask me inconvenient questions. To the doctors, they say this is a big problem for them now. Before the patient comes to the doctor, he has gone to the net, he has read everything, he knows which medicine the doctor is likely to prescribe, what is the difficulty for that medicine, and then he starts asking the doctor. He cross-examines the doctor and says, will this not have XYZ side effects? And then the doctor, unless he is equipped, he will not be able to answer. No, that is why I say the law has to cater to a knowledge society, not an ignorant society as it was. When I started practice in 1973, you know how lawyers take people for a ride. When I say something, that is the law. He doesn't discuss with me what defense in a criminal case can be taken by him. Right? You should have known. See, when I say, I remember, I went to the Retd Island to conduct, just personally, I went to Retd Island to conduct a case. Now, there everyone knows everyone. So, dispute of identity would have fallen to the ground. And and therefore I took up a defense of private defense, because private defense in Indian law is one of the defenses which ought to be encouraged. I took up the defense of private defense, and then at the end he had to do his 313. Till then he is not understanding what is happening in court. So when the 313 questioning came, I told him, you have to say that I was there, then this man attacked me, and then I tried to defend myself. I pushed him, he fell, and he suffered the injury. Then I found, when you go to Lakshadweep, there was only one case. You have to go by ship and then be there. This man would not come and talk to me that night at all. And then ultimately I called somebody, why I have not seen Mr. Koya, why is he not coming? Then he came and told me, oh, we are admitting the offense. He did not like it. He did not understand that at all. And I had to do a lot of time. Then I said, no, you don't say anything. I'll give it in writing. You just give it to the court. So that is the way. We are all used to dealing with, in an age of darkness, we are not dealing with knowledgeable persons. Today, the circumstances are different. Any professional for that matter. The ivory tower of the professions are gone now. Everyone comes to you with all information about them. Now, you will be very interested with all these portals going out. Sometimes a person comes and asks me, 3 days back there was a decision in live law. No, if you do not know that, you are going to be a misfit in the profession. That is why updating yourself becomes very important. Pursuit of excellence becomes very important. Otherwise you are going to be very, very unsatisfactory, inadequate professionals also. Because in a knowledge society, from a professional, a lawyer or a doctor, people are expecting a different kind of approach. The law cannot say we will stick to the 112 presumption as we had years back. We have to update ourselves with the knowledge of all branches that are developing. Okay, you wanted to ask something. Sorry, I could not.
When section
Still relax, sit down. No, don't worry.
When section 112 has to pass through the test of reasonableness of Article 14, it has also to be passed through Article 21, right to privacy also.
Yeah.
So, by the case...
Our court has considered. Our court is very interesting.
Yes,
good question that you have asked me. There was a question raised. In which decision was that? Tell me. This 14 or 15 decision, the issue arose. He would be protected by a right of privacy not to give blood sample. I don't know how far it is correct. It's a different question altogether. For the civil disputes, she will not be. In a criminal investigation, the provisions are there.
Supreme Court has turned down this.
Yeah, that's what I'm saying. See, in that the Supreme Court said,
also this argument was
yes, narcotic, Selvi also this question came. But after the right to privacy decision, maybe it would require reconsideration. I'm just leaving it there. But the Supreme Court said, in that decision, give me that decision. Nandalal. Yes.
No, Sharda.
Sharda. I am not talking about Sharda. Okay, Sharda also it said that. The Supreme Court said, if you don't want to give the sample, don't give it. But you may attract the presumption, adverse presumption under 114G.
Yes.
It's your choice. If you think your right to privacy is being invaded and you don't want to give the blood sample, don't give it. No problem. But the other side will be able to request the court to draw an adverse inference against you for not having furnished this. The only thing. Nobody is going to compel you, tie you down and take the blood from you. That cannot happen. That may not happen. But the court said, yes, if you don't want, don't give it. But then be wary of the adverse inference that may be drawn under 114G.
Any more questions, please?
Okay, good question. In the light of the privacy decision, which is now raised to the level of a fundamental right, how will you look at it? I don't think there's a problem also, as he said, in Selvi it has been said, you can even be asked to undergo all the other tests. So there's only one other test. It's the most non-invasive test. If you agree to draw the blood, the rest of it takes place in it's not invasive. See, in fact, what is that other test called? Your serum test. The truth serum test is all
Light
invasive.
detector.
Invasive. Lie detector test is invasive. There is no invasion here at all. You just take the blood, send it to the DNA expert. That's all.
Sir, we'll take your autograph. Thank you very much, sir.
Every time I have come to this, I do come as a listener also. But every time I have come here, I have gone back with the feeling that my time has been well spent. I am very happy. The way you have reacted also, I feel that I have spent my time.
Every time we do enlighten equally, sir, and I give my time. You can take this. Just signature. Next here you can write message. You can write your message. Friends, thank you very much. Really, it's a reopening. It's after vacation. There's a good attendance.